So welcome here to another edition of Ed Talks. I'm going to talk to you today about continuous violence of the family. I've seen a lot of this going on lately, a lot of charges for this particular offense. I'm here once again in my office, in my barn out in the country, and I got a phone call the other day from someone who's experiencing this, and I thought a good idea to talk about it, explain what it is, because it's a little confusing. Continuous violence, which is found in Penal Code uh, Section 22.01A1, um, talks about family violence. And in the typical family violence case, you've got someone calling the police, 911, to complain about a family member, a husband, boyfriend, girlfriend, what have you. And police come out and talk to them. And if the allegation holds, then the police then calls the DA and then the charge is filed for misdemeanor assault of a family member. We've talked about that quite a bit already. But continuous family violence is a different animal that turns that Class A misdemeanor into something much worse, a felony of the third degree. The continuous family violence section states that if proof has been provided, allegation has been provided that there's been family violence that has occurred on more than two or more occasions within a 12-month period of time, then the state can charge the third-degree felony. The problem with this particular offense is that there doesn't have to be any evidence of this particular first event or first two events or what have you. If the individual never called the police, there's no evidence other than this mere allegation, the DA still is authorized to file the charge. And a felony operates completely different than a misdemeanor. It's way more serious. The bail's a bigger deal. The bail conditions are a bigger deal. And obviously the potential for punishment is much greater. Third-degree felony carries with it a possible punishment of 2 to 10 years. It's troubling to me that the charges are filed so frequently under this provision. The DA that has a tendency to upcharge if given the opportunity. If they can file a felony, they're likely to do that. But there doesn't have to be a whole lot of evidence to do that. And I think ultimately the DAs and the courts understand that, judging by their offers and judging by the way they handle it. But it's still a mess for individuals that are charged with continuous violence. How do you handle one of these continuous violence cases? There is help to the defense on these types of cases. When you have an assault of a family member, the police will come out. Maybe the individual is crying, teary, what have you. Police like to charge felonies, so they're going to ask various questions. It used to be, back when choking first became a felony, that cops were all hopped up on filing these choking cases. So they'd always ask, well, did he touch your neck? And ultimately that touching of the neck might turn into choking, which would turn into a felony. Now we have these continuous violence cases that you're going to have a police officer asking the complainant, hey, what happened? If she or he tells the officer, and then the officer is going to ask the operative question, hey, has this ever happened again? And what was the date of the event? If an individual is making the story up because she or he has an axe to grind, it's simple for them to make up this offense that occurred within the last 12 months, this mystical past, and then the cop tells the DA and the felony is charged. The DA, though, has some problems, and the defense has some help with that, because in the event of a trial, the DA is going to be tied to those events. So they go into trial if they are unable to prove that the first event occurred, or forget that. If they're unable to prove it beyond a reasonable doubt, if they're unable to show that the complainant is a truth teller on that first event, they're going to have trouble convincing the jury on the event when the police came out as well. So The DA knows this is a problem. The assistants know this, and good defense attorneys are going to know that. And they're going to handle it appropriately. My experience has been that the assistant district attorneys in the court who have these cases, if we don't have a prior charge defense, we don't have a history, we're gonna see that they understand there's problems. That's going to be reflected in their offers. Frequently, we're going to get misdemeanor reductions, for instance, or outright dismissals if we can show some proof that, hey, look, the date that she says that this occurred, this is what really was happening. We can show by some other evidence, and maybe get the whole thing dropped. So it's bad that you get charged with continuous family violence. I'm not saying it's not, especially in the beginning, but this is manageable like all other criminal offenses, and try not to freak out too much. We'll see you on the next Ed Talk, and we'll talk about some other things that are going on. Hopefully we'll get that done in about a week or so. When I come out to my barn and I've got this set up, I like to do these talks, and that's when we'll meet again.